All right. I'll call the Senate Judiciary to order. Will the Secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Dondera Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here. Please mark Senator Harris present when she arrives. We have two bill hearings on our agenda for today. I believe both of them are from the Attorney General's office, and unless you want me to go out of order, I was planning to take them in numerical order. All right then, we will open up the hearing on SB 34.
Good afternoon.
You
Good
can go ahead.
afternoon, Chair Scheibel. Can you hear me? Good
Yes.
afternoon, Chair Scheibel and Senate Judiciary Committee members. I am Leslie Nino-Piro, General Counsel for the Office of the Attorney General. You may recognize my last name. Yes, I am the other half of Team Piro. Some may argue the better half. But my purpose here today is to introduce SB 34 and the proposed amendments. The bill would make two needed changes to existing law by explicitly authorizing the official attorney to provide legal services to government actors when they are not named defendants in a lawsuit, and second, allowing the Attorney General to independently determine that it is impracticable, uneconomical, or a conflict of interest to provide legal services to executive branch agencies on a particular matter, thus conforming with related statutes. Since Section 1 would affect both state and political subdivisions, I'll use the term official attorney, which Nevada law defines as the Attorney General or the chief legal officer of a political subdivision, such as a county district attorney or a city attorney. Section 1 does a few things. First, it would authorize the official attorney to provide legal services to a government actor who is summoned or subpoenaed to appear in a legal action. This section is intended to address a statutory deficiency for situations when a government actor is not a named party but receives a summons or subpoena for their testimony. For example, the AG's office has encountered this scenario when an NHP trooper is subpoenaed for deposition testimony in a lawsuit between two private parties based on an accident report authored by the trooper. Section 1 would provide explicit statutory authority to prepare the trooper to testify and then represent the trooper at the deposition. This codifies long-standing practice of multiple administrations. Next, Section 1 will allow the official attorney to determine whether providing legal services is in the best interests of the state or political subdivision. Representation is not mandatory. So I'll provide a general example. When a government actor provides sworn testimony in a deposition, the plaintiff in a civil lawsuit may amend their complaint to name that government actor as a defendant. If the government actor seeks legal advice before the deposition, the official attorney may examine the nature of the case and the allegations and determine that providing legal services is in the best interest of the state or political subdivision, as it may help limit potential liability exposure. Finally, Section 1 models existing law by authorizing the official attorney to employ special counsel under certain circumstances. Section 1 also provides a path to withdraw from the representation if a government actor retains their own counsel or a court authorizes the withdrawal. Further, Section 1 makes it clear that it does not alter or otherwise affect any immunity or protection under the law. The AG's office is proposing 3 minor conceptual amendments to Section 1. First, we will amend Section 1, subsection 1, to delete the term state legislator, since the LCB represents state legislators. Second, the term political subdivision will be added to Section 1, subsection 1A, to reflect that the official attorney will consider either the best interests of the state or political subdivision, depending on the government entity affected. Third, Section 1, subsection 4 will be amended to correct a Scrivener's error, changing the term impractical to impracticable, which will mirror the term currently used in other applicable statutes. That's it for Section 1. Section 2 makes conforming changes to align with Section 1. Very simple. Section 3 would delete the phrase "at any time prior to trial" from NRS 41.03435. This change is necessary because the Attorney General may need to employ special counsel for a range of civil matters that do not culminate in trial, including the scenarios I just described in Section 1. Civil matters are not all lawsuits leading to trial. Nevertheless, the expertise of special counsel is sometimes needed. I'll give you an example. The AG's office has employed special counsel to assist in collective bargaining negotiations when no Deputy Attorney General had experience in that highly specialized area. Further, the pre-trial time limitation is no longer workable because the AG's office may identify a conflict of interest after trial in the appellate stage. Section 3's change allows the AG's office the flexibility it needs to meet the demands of modern law practice. The AG's office also has a conceptual amendment to the original Section 3. We will keep the phrase "other than the state general fund." We're keeping this phrase because the AG's office does not fund special counsel through the state general fund. That's it for Section 3. Section 4 harmonizes NRS 228.110 with other provisions of Nevada law, addressing the Attorney General's decision regarding the need for alternate counsel. With limited exception, the statute designates the AG's office as the exclusive legal counsel for all state matters arising in the executive department. A single exception is provided when the AG's office is disqualified to act in a matter. Disqualification is a specific finding of fact and conclusion of law by a court. This can pose a problem because the AG's office routinely provides advice to the executive branch agencies when no judicial proceeding exists. Thus, no judge is presiding to disqualify the AG's office. As noted, multiple statutes authorize the Attorney General to independently determine that providing legal services would be impracticable, uneconomical, or a conflict of interest. So Section 4 seeks to add the same phrase to NRS 228.110, thus harmonizing the statute with related Nevada law. So I'll provide an illustration. Legal services from the AG's office may be impracticable or uneconomical in limited circumstances where deputy attorneys general lack experience in a highly specialized practice area, such as debt collection, bankruptcy, or privacy and data breaches. Additionally, a conflict of interest may arise between two state agency clients or between the AG's office and one agency client. In those situations, the AG's office must act quickly to comply with the Nevada rules of professional responsibility, and employment of special counsel may be necessary. Section 4 would make the conforming statutory changes necessary for the Attorney General to independently determine whether alternative counsel is needed. And this will allow for the most efficient, and effective client services. Lastly, the AG's office will propose the following amendment, adding a subsection C to Section 4. It will state, compensation for any attorney at law or counselor at law employed pursuant to subsection B must be paid in accordance with the requirements for special counsel prescribed by NRS 41.03435. The intent of the proposed amendment is to allow the AG's office to swiftly identify alternate counsel and, if necessary, negotiate favorable rates and contract terms. Finally, Section 5 provides effective dates for each section in this Act. That concludes my presentation of SB 34, and I am available to answer any questions you may have.
All right, thank you so much. Are there questions from members of the committee? All right, I have, excuse me, a clarifying question. You indicated that this would conform with our current practice, is that correct?
Thank you for the question, Chair Scheibel. Leslie Nino-Pirro for the record. Yes, that has been our practice for multiple administrations, a longstanding practice.
Okay. And so would it be deputy AGs then who advise members of the state police?
Leslie Nino-Pirro for the record. Yes, that is correct.
Okay. Other questions from other members? Senator Krasner.
Thank you, Chair Scheibel. Thank you for your presentation. You said that with the changes in here, the Attorney General could independently determine if it was impracticable, uneconomical, or could constitute a conflict of interest, and then appoint independent counsel. Who does the Attorney General have to go to now rather than doing it unilaterally as this bill would suggest? Thank you.
Thank you, Senator. Leslie Nino-Pirro for the record. The way the statute is currently set up, it suggests that the Attorney General's office would have to go to the court. However, on a routine basis of providing legal advice, there's not always a pending legal matter. So there would not be a court matter in order to file a motion for disqualification. So it's a gray area within the statute that we're trying to clarify.
So in private practice, if an attorney or law firm wants to ask for independent counsel, would they have to go before a court and proffer a motion?
Leslie Nino-Pirro for the record. In private practice, if disqualification is a legal term of art, so it always seeks the involvement of the court. So when we are providing day-to-day advice to state agencies, there's not always a court matter to file a motion in. So as I understand the statute, it would contemplate the filing of a writ petition or another original matter with the court. And so you might imagine that could take days or even weeks. And so this would be a far more efficient and effective resolution for state agencies rather than having an original petition or original matter filed with the court.
What about the district attorney's office? Now, if they wanted to appoint an independent counsel, what would their procedure be?
NRS 228.110 only affects the Attorney General's office, and executive branch agencies within the state. It does not affect political subdivisions or the county district attorneys.
Could I ask our legal counsel, please, then what would the district attorney's office do? What would their procedure be if they wanted to appoint independent counsel?
We can definitely pass the question on to legal counsel. In case anybody doesn't know, they're not in the meeting because they're busy drafting our bills, but they are working overtime to answer questions before and after our meetings. So we'll circle back around with you on that one. Any other questions from members of the committee? Senator Ornschell?
Thank you, Chair, and good to see you, Ms. Pirro. My question here on Senate Bill 34, I feel like it could expedite certain, like if private counsel needs to be appointed. I know last year there was a disagreement, I think, between the Secretary of State's office and the Attorney General's over interpretation of certain statute, and private counsel, I think, had to be appointed for the Secretary of State. Am I reading this correctly? This would expedite that happening and them getting the private counsel when they decided to appeal versus kind of having to drag that out?
Thank you for the question, Senator Ornschell. Yes, Leslie Nino Pirro, for the record, that is correct. It is intended to streamline and to speed up the process.
Thank you, Ms. Nino Pirro. Thank you, Chair.
Thank you. All right. I don't see any other questions, so we will move to testimony in support of SB 34. Anybody wishing to give testimony in support, please come on down to the table either in Carson City or Las Vegas. Not seeing anybody coming to either table, we will go to testimony on the phone, please, in support of SB 34.
Thank you, Chair Scheibel. The public lines are open and working. However, there are no callers to offer testimony at this time.
All right, then, we'll go to testimony in opposition to SB 34. I'm not seeing anybody coming to either table. Is there anybody on the line now, BPS?
Thank you, Chair. The lines are open and working again. However, there are no callers at this time.
All right, we'll try one more time with testimony in the neutral position. Anybody wishing to give neutral testimony, come on up.
Tanya Brown, spelled TonjaBrow, and Advocates for the Inmates and the Innocent. Something that hasn't been discussed, and it should be brought to your attention, and I base this on experience. What happens when a plaintiff, such as an inmate, sues the state due to some wrongful acts committed by the NDOC? And the Attorney General's office is now representing the state in this. And I will tell you that at times the council will submit information in camera for the protection of the NDOC staff, which I understand. But when the court, the judge makes its decision on evidence and information provided in camera to the judge, and it is wrong information or Brady violations by the DAG, and the court rules in favor of the state, the AG's office, and then later it turns out that the DAG had withheld exculpatory evidence that would have supported the plaintiff's decision. Where does that come into play? Because by the time that we get around to it, that the statute of limitations have run out, the plaintiff, which is the inmate, has been harmed, has had irreparable harm done to him, and nobody pays the consequences. And so, I mean, I'm basing this on information that I am privy to because I actually became a part of something, and how I learned about the DAG withholding evidence was in the wrongful death suit when I was able to have access to the NDOC files. And it pertained to myself, which became a part of a settlement agreement that the state breached. And so when we're dealing with inmates, they do have lawsuits. How can we trust the DAG from doing their job properly and making sure that the inmate does receive a fair trial and that the DAG, those representing them, are held accountable? Who oversees the AG's office? Thank you.
All right, I don't see anybody else coming to the table to testify in neutral, so we will go to the phone lines, please. Anybody with neutral testimony on SB 34?
Thank you, Chair Scheibel. There are no callers to offer neutral testimony at this time.
All right, unless the sponsor has any closing remarks, I'm going to take that as a no. It's harder to see from the couple hundred miles away. Then I will close the hearing on SB 34, and I will open the hearing on SB 61.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Homa Woodrum, first name Homa, last name Woodrum, and I'm a Senior Deputy Attorney General with the Nevada Office of the Attorney General. Also presenting Senate Bill 61 today is Clark County Chief Deputy District Attorney Colleen Baharav. Is a joint bank account a gift? That is, when you add a person to your account, are you intending to gift them all of the money in that account at the very moment you add them? We believe the answer is no. Senate Bill 61 clarifies in statutes the rights of vulnerable and older persons who are account holders who add other persons to their bank account to ensure that they are not wiped out in that moment but are protected under law. Protected from exploitation, theft, conversion, protected in their own property rights. Senate Bill 61 is narrowly tailored to make the law consistent with the expectations and practices of those who use joint accounts to manage their affairs. Senate Bill 61 does not create any new penalties under law, but instead makes clear the legislative intent that where the evidence supports a criminal conviction, that case can be brought where a joint account holder was part of the crime. Without Senate Bill 61, courts will continue to require proof of criminal intent at a very specific moment on the part of the added individual at the time they are placed on a joint account, but not for the life of the account. Misappropriation by its very nature comes days, months, and even years after the creation of such accounts. Section 1 adds language to Chapter 200 of Nevada Revised Statutes to expressly state that the mere fact that an account is held jointly does not preclude charges against a person for exploitation of an older or vulnerable adult. Sections 2 through 4 make conforming adjustments to reference the new section. Section 5 addresses NRS 100.085 relating to accounts held in joint tenancy, adding language to indicate the clarification that a joint account holder may be subject to criminal liability. Without Senate Bill 61, there is little to no recourse for the misplaced trust of a vulnerable person adding a joint account holder or naming a power of attorney who makes changes to their bank accounts. This bill is not intended to interfere with the common practice of using joint accounts to gain assistance with estate management, but to allow for criminal penalties where the evidence supports it. Cases of exploitation are devastating for victims and deprive them of the benefit of the care and comfort of their own savings and income. When those victims must seek public assistance because of exploitation, current law forces them to seek hardship waivers instead of being directly eligible for programs such as Nevada Medicaid. There is also, of course, the cost to the state to cover those services that an individual saved to cover themselves. When public guardians must step in to assist, they are left with little to no funding to provide for the protected person's needs. You may be wondering, has this always been this way? The answer is no. Our court's interpretation has evolved between 1996 and 2018. You'll note two cases mentioned in the introductory language for Senate Bill 61. In 1996, the Nevada Supreme Court held that the mere fact that an account is held jointly does not preclude a theft conviction. In 2018, the Nevada Court of Appeals found that criminal intent must be proven at the moment of joint titling for this to be possible. This shift, despite the statute regarding joint accounts being on the books since 1977 and amended in 1995 with no legislative history to indicate otherwise related to exploitation matters, dealt a devastating blow to law enforcement efforts to fight financial exploitation of vulnerable adults. Cases that could have been brought before 2018 are nigh impossible. The reality of joint accounts is this. Nevadans add others to their accounts as an informal estate management and planning tool. They are seeking help with bill paying, online banking, with the expectation that a person they trust will treat those funds appropriately and not wipe them out. Senate Bill 61 does not hinder the customary or even shared use of joint accounts. It stands for the proposition that if person A adds person B to an account, person B is not immune from consequences if they deprive person A from their rightful use of that account. Senate Bill 61 stands for the proposition that if person B says, "I'll help you pay your bills," only to misappropriate those funds later on, person B can be held accountable. Senate Bill 61 stands for the proposition that if person B is the financial power of attorney of person A and creates a jointly entitled account only to empty it for their own benefit, law enforcement can successfully investigate and refer the case for prosecution. I think often of one particular man whose son took over $327,000 from a joint account, and the gentleman was required to obtain over $70,000 of public assistance from Nevada Medicaid up until he passed away. I think about how he never expected that adding his son to his account would leave him destitute. It bears repeating, a joint account is not a gift. The law does not intend that to be the case, and Nevadans have no expectation that their property rights are being affected in this way. I am privileged to be presenting Senate Bill 61 on behalf not only of the Office of the Attorney General, but our law enforcement and social services partners statewide who have wrung their hands time and time again as bad actors walk away with the resources of people who trusted them. Our office has been approached by our colleagues with the Public Defender's Office related to Section 5, not referencing back to older and vulnerable adults, and we'll continue to work with them as far as clarifying that specific section and their concern. I'll now pass the presentation to Chief Deputy District Attorney Colleen Baharav, and then we'll be happy to answer any questions. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Chief Deputy District Attorney Colleen Baharav, and for spelling for the record, as that's a whole lot of letters in a name, it's Charlie, Oscar, Lima, Lima, Elephant, Elephant, N. I can't remember what those are. And then the last name is B as in boy, A, H, A, R, A, V as in Victor. I'm here actually in Las Vegas with Senior Financial Analyst Colin Haynes with the Las Vegas Metropolitan Police Department. And I am also honored to be able to present this Senate Bill 61 along with Ms. Woodrum. The reason that we are providing this testimony here to you today, and if I could just echo Ms. Woodrum, is that a joint bank account typically for our elderly and vulnerable persons is not meant to be a gift when a person is added just for the sake of helping that elderly or vulnerable individual with their daily lives, their bills, going to the doctor, grocery shopping. Senate Bill 61 would allow prosecution where circumstances or facts would support it. It would allow the totality of the circumstances to be taken into consideration where currently they cannot be. I actually have a case at the moment where a person was added to a bank account, and luckily there was a witness to the conversation prior to this person being added to the bank account. Absent that witness, we would not be able to prosecute this case. This person was added to the bank account for the sole purpose of assisting an elderly man who was living with her and her family with paying his bills, going grocery shopping, and things of that nature. And he was very generous with his family, and there's no allegation that those gifts prior to him entering hospice were in any way not given freely. However, because the bank account was titled in joint tenancy, when the elderly individual went to hospice care for end-of-life care, the other tenant on the account emptied out $441,000 over the span of just a couple of days. The only reason that we are able to prosecute that case currently is because there was an independent witness who observed the conversation into why this person was being added. However, even if we are able to prosecute through jury trial, it is possible and probable, given the current state of the law, that this individual will not be convicted of the crime because the way that the law is currently focused after the NATCO decision is that this woman was entitled to that money because she's a joint account holder. We are asking that Senate Bill 61 be given due consideration. We're asking that it be retroactive to clarify the intent of the legislature all along. We understand that when the laws were changed in 2003 and even 2015, it was with the intent that our elderly and vulnerable populace not be taken advantage of by persons who are trying to help them or even told to help them. Most of these crimes are crimes of opportunity, and they're not predisposed to commit them prior to being added to the account. It is only after something either happens with that person whose bank account it originally was that oftentimes the intention to steal arises. So that concludes my presentation, and I believe Ms. Woodrum and I are open for questions, or Mr. Haynes, if you would like to speak with him as well.
Thank you very much for your presentation. Are there questions from members of the committee? Vice Chair Harris.
Thank you, Madam Chair. So my first question is, why older persons and vulnerable persons as opposed to just vulnerable persons, given that we're assuming, because it's only 60 years old, right? So I guess shouldn't the default be that an older person maintains capacity until they become a vulnerable person?
Homa Woodrum for the record. May I go direct? Senator Harris, thank you for the question. The statutory scheme in Chapter 200 features all of the language related to abuse and neglect of older adults, but then also people with disabilities, who are individuals who are over 18. So the catch-all language to match the pattern of that chapter is that individuals who are vulnerable are people who are over the age of 18 who may have been deemed to lack capacity, but even those who have a diagnosis of a disability, not to say that they didn't have the capacity perhaps to make the decision to add someone to the joint account, but that the intent here is to give them that enhanced protection, because the likelihood that they are adding someone to get assistance with their affairs makes it even more likely that it's not their intention that they meant that money that their Social Security is going into, their SSDI is going into, was intended to be a gift. So the distinction throughout Chapter 200 is older and vulnerable. So we have our individuals over 60. Now, as to the individuals over 60, we're not presuming that someone over 60 does not have capacity to manage their affairs. We just have enhancements already under statute that address why we would consider a crime against those individuals to possibly be more something we'd be more attentive to, and that's in part because of the cost to the state and the cost to our community when someone's life savings are wiped out and then they become subject to public assistance because of that.
Thank you so much. Is there anything here that would require these folks to be put under guardianship after something happens? Because ideally, that's the mechanism that's in place. If you aren't capable of managing your financial affairs, you wouldn't add someone as a joint to your bank account. You would get a financial guardian or the POA for finances, right? And then we already have the legal structures and protections that are in place to ensure that they are using that money to actually take care of you. So are we ensuring that once this happens, these folks are then put under a guardianship of some sort?
Homo Woodrum for the record. Thank you for the question, Senator Harris. The issue is that guardianship is at a very extreme end of the spectrum, right? We call it the civil death, right? It's an incredible intrusion into somebody's life, and we've engaged in a number of reforms to say that people are able to manage their affairs. People are able to decide who they trust. Senate Bill 61 is not trying to say that if you get this kind of help, then you need a guardianship. We do have the framework where someone does end up in the guardianship, and I would mention that what usually happens is someone has already been exploited, right? Adult Protective Services or law enforcement come in, and as someone who has litigated those what we call civil recovery actions in guardianship, it is incredibly difficult without the assistance of law enforcement, without the assistance of the criminal side of the house to bring these cases. I had one case where I represented the Clark County Public Guardian, and an individual had $70,000 stolen from her by someone she trusted. And of course, we know that the law presumes capacity. So until a judge says you lack capacity, it doesn't even matter if a doctor sort of speculates about your capacity. You have capacity. You have the right to contract. You have the right to go about your affairs. So this individual lost $70,000. And we, as in the Public Guardian's office, had no funds to pursue that person, right? We had no resources to pursue them, and we had to use a petition for instructions under NRS 159 to allow the court to bless us walking away from that recovery, and it would even have been double damages under the law because there were no resources to do so. So when we have been approached at our office and through the district attorney's office where our investigators are unable to go to the next step with these joint accounts, it's because it cuts them off, right? It cuts them off from the ability to start the case, to bring the case, because it's going to get dismissed because of the very narrow proof about the moment of the joint account. And as Ms. Baharov mentioned, usually someone is actually using less restrictive alternatives to secure that account, to get someone watching that account. And we want to also allow people that the law says, in a perfect world, as an estate planning attorney, I would love for everybody to go get the complete bells and whistles Cadillac estate plan. The reality is that people in Nevada do what works for them. And you know what? It's really easy to just add your son or daughter to the account so they can make those bill payments. So we're not implying in any way that that decision to trust someone implies a lack of capacity or a diminishment of capacity. But we're saying on the back end, when we see these egregious cases, we need to be able to bring criminal prosecutions against the people who betrayed the trust of someone that, that thought that they were going to get some help.
Thank you for that. I guess that's the piece I'm trying to struggle with, right? Are we actually saying they have the capacity to do this? Because sometimes you get scammed, right? So it seems to me we're either arguing that you sign over and you are wiped out, and you signed over because you were worried in the first place that you couldn't manage your finances, then that would be indicative that you maybe don't have the capacity to manage your finances any longer. It's either that or it doesn't, right? And then you should be able to enter into a joint tenancy like anybody else is able to. And, I know we're trying to find that middle here, but there's a little bit of, I don't know, tension between those two ideas. But that's not my question. I guess I'm really trying to figure out, does this potentially have like a chilling effect, right, on folks who might be willing to step in and say, yeah, sign me on. And then you do take out all the money because, let's say, there's some legitimate reason and now you're being investigated, right? How do you prove that you took it out because there was some, big purchase that needed to be made, right? Is there any concern that this would get less folks willing to do that intermediary step before a guardianship?
Thank you for the question, Homa Woodrum, for the record. Just as a side note, related to, does the law create some kind of a catch-22 where asking for help creates an implication that you needed that help? I would point to NRS 162C, which is our Nevada Supported Decision-Making Act, which makes a very broad statement that the act of asking for help should not be used as some kind of implication that you need a guardianship, and it can't even be used as evidence in a guardianship. And I believe that Senate Bill 61 would fit within that framework, because no one would be saying that because you were exploited, now you need a guardian. That is not the goal. The goal is, and often people use a guardianship to get someone the help after they've been exploited, but if our law enforcement partners can pursue the bad actor, we can actually cobble together our social services measures to actually help that person in a better way than making them reach into guardianship to get that assistance. Related to a chilling effect, in a best practice scenario, we would like to see people taking the measures to protect their rights and document their wishes when they are asking for help, such as a supported decision-making agreement, such as a power of attorney. If Senate Bill 61 causes someone to pause and put that seatbelt on, then I think that that's a positive measure. It will not, I don't believe it would have a chilling effect on the day-to-day operations of family members who are helping each other. Unfortunately, in the field that we're in with elder exploitation and abuse and disability, people with disability being abused and exploited, we see all the bad cases. We don't see the 99% of times that a family gets together, comes up with a plan to help mom, and everything goes great. We're seeing these egregious cases. I don't believe it would have a chilling effect on your run-of-the-mill joint account, people putting joint assets together. For example, in family law, when we have a divorce and there's a joint account, we'll do a joint preliminary injunction. There's an implication there that both parties heading into that divorce had joint and several rights to that account. We're not touching that. It is purely in the case where we have all the other evidence of exploitation, but the door has been closed to bringing that case because there happens to be a joint account, and we can't prove that very specific intent at the moment of the addition of the account, especially since the senior or vulnerable person is adding that other individual. They may not have even had bad intent at the time, but then developed that intent. Either they fell on hard times. Your example of maybe they're told, oh, go take a loan out of that account. Well, then the other evidence would have to be, present to bring a case. It's not meant to be a gotcha, and that's part of the concern that our colleagues with the Public Defender's Office had, was that, is this narrowly tailored to older and vulnerable accounts and these very specific kinds of exploitation where there are other elements to prove? So it's our position that this wouldn't have a chilling effect, and in fact, it would make the law match what the community's expectation is, that when they add a person to an account and something goes badly, then our law enforcement will help make them whole.
Other questions? Senator Don Darrell-Loop.
Thank you very much, Madam Chair. I'm hearing all this, and I may be confused about why we need this bill. I mean, I went down this road with my mother, and I can tell you I could not open an account without her sitting there and signing the piece of paper. We missed one little account, and I can tell you I could not take that money out of that account even after she passed away, even though I was the POA, even though she had an estate, even though she had the gold Cadillac. And so I guess I'm just a little bit confused why we need this. I get the vulnerability, and I get that people do things wrong. I may or may not be in your context of the definition of an older person, which is just a little scary. But could you give me a little more information and tell me why 60 is that number, that magic number? Since I may or may not fall into that category.
Thank you, Senator Homa Woodrum, for the record. A little bit of background is that the legislature passes laws and may not see how they might be employed through our courts. And what happened was that there was a court case, the NATCO decision, where the court took a very specific interpretation of kind of an unassuming law. So the law on joint account says when you add someone to an account, you both have rights to that account, in a nutshell. What the NATCO decision said was that that you would have to prove specific intent at the moment that you were added to the account, that you wished ill, right? That you meant to. So for example, if somebody's being added to mom's account, the day that they're in the bank getting added, they would have to be sitting there thinking to themselves, I'm going to empty this account for my benefit. And if that intent isn't there, the court case in NATCO seems to close the door to prosecutions of cases where maybe someone gets added to the account on Monday. By Friday, they log into the bank account and they see that there's $300,000 there and decide that maybe they'd like to have it and take it away. The issue with the age cutoff for over 60, that's in Chapter 200 is a criminal chapter. And the law has always said that older adults are age 60 and up. Actually, nationally, that cutoff is age 55 and up, which is, I think we'll probably need to do some more branding when it comes to...
It's too late for me to do a bill.
But it's not, I think, I will say this, that words matter and the words we use matter and words are evolving. Of course, we use the term older adult, and to Senator Harris's prior questions, we don't want to create some impression that once you hit a certain age that we're assuming things about your capacity or your ability to manage your affair or choose who you trust. It's the framework we have. I think that the idea is that maybe that gets adjusted over time. At the moment, the law talks about adult protective services addressing people who are over 18 who have disabilities, and people who are over 60. That's the framework that we have, and that's the reason that the bill is using it in this way. But I will say, specifically in the NATCO case, there was language that closed the door to bringing cases, even though this body the law didn't change. 1977, we got a chapter about, we got a provision about joint accounts. The amendment, all the testimony for the amendment in 1995 was from the banking kind of side of things where they wanted some clarification. So never in this story has the legislature come out and said, here's how we meant to say this, or here's how we intend this to be read. Instead, the courts have been kind of reading the tea leaves. The way that they've been reading those leaves has been to say, this is a very bright line thing. When you add your daughter to your account, you just gave her the account. And we're really concerned about the cases of exploitation that we're unable to pursue because of that.
Follow up, Madam Chair. But the problem is, in my mind, is people over 60 do get married. People over 60 do allow other people on their accounts for other reasons. People of all ages may have somebody on their account for any reason. And all those accounts, when I go to the bank, require that person to sit there in the bank with me to sign a piece of paper. I just can't go up and say, oh, hey, my mom told me she wanted me to be on my account, her account. Or my husband said, we're going to have a joint account now because we got married yesterday. And when I go in to take that money out, they don't say, well, did you think about doing this the day that you made that account? Like, there's no, how do you prove that I had ill intentions? Or how do you prove that a husband who takes 50% of the money out of an account before he ever tells the wife he's going to get a divorce, or the wife, the reverse, the wife takes the money out before she ever tells her husband, oh, by the way, we're getting a divorce. How do you ever show that intent? Because you could have that intent from day one, or you could have that intent on day 101.
Thank you, Senator. I would point to page 3 of the bill has some language from the existing statute relating to exploitation, and it defines exploitation. I absolutely appreciate the concern that you don't want to catch people who are going about their day-to-day lives in sort of this web. It says under the existing statute that exploitation means any act taken by a person who has the trust and confidence of an older person or a vulnerable person, or any use of the power of attorney or guardianship of an older person or vulnerable person too, and then it leads into obtain control through deception, intimidation, undue influence. So the couple that's over 60 that gets married is not going to be in an exploitation situation because it is your run-of-the-mill expected use of a joint account. We're talking about, for example, the sweetheart scam, right? Somebody who is sitting in the bank and is being added and is newly married, and their only intention ultimately may be to empty that account, but it is incredibly difficult to prove, as you mentioned, what's on someone's mind at the time. What we want to be able to do is look at their conduct. How did they manage that account? Say that account only ever had an annuity paid into it, a Social Security check paid into it, and for months, years at a time, and then actions are taken inconsistent with sort of the pattern of ownership of that account. Exploitation of an older or vulnerable adult has a high bar of proof already. What we're concerned about is that at the moment, or since 2018, we have been unable to bring those cases at all, like the case of the $400,000+ or the $375,000 out in Elko, because we are unable to, parse out what happened maybe 10, 15 years ago when someone was originally added. So the idea is that we want to be able to bring the case, bring the evidence. It's not meant to catch individuals who are, sharing an account, maybe taking 50% of the account. I guess if the concern is that the over 60 cutoff implicates people who are engaging in certain activities that would be more like somebody who's under 60, I would point to the exploitation requirements under statute and say that those cases aren't exploitation whatever they age. They have to do with undue influence and really taking actions that deceive and trick somebody into letting their guard down and then taking their funds. So it's part of a context that I don't think you would be even in that chapter if you were talking about your run-of-the-mill spousal situation, your son or daughter who's helping, or that sort of thing. The cases would be brought, and if they shouldn't have, they don't have sufficient evidence, then that's something for a judge and a jury to decide. At the moment, the way the courts are interpreting this, we cannot even bring the case because there's no way that we can prove what was on somebody's mind at the moment they were added. And often that ill intent comes later, say they fall on hard times, gambling, addiction, and then they've deprived someone of their life savings and their resources. So I do understand the concern, but I do think that it's addressed because this is very narrowly in the context not of any joint account, but where we're looking at an exploitation case that happens to involve a joint account.
Okay, thank you. I would go back to my original question, but I just am not clear, especially after you pointed out the Section 3 of exploitation. But I'll stop here and let somebody else take a turn. Thank you.
Thank you. I'm actually going to interject to ask my own question because I think this might also help clarify things. Because my understanding is that we are taking this I'm trying to figure out how to phrase this. Did you consider, and is there a reason that this bill is better than simply stating that holding an account in joint tenancy is not an affirmative defense to any of the crimes enumerated in 200.5091 to 200.5099?
Thank you for the question, Chair Scheibel. The way that this bill was crafted was meant to mirror kind of the jurisprudence of how the courts have been looking at the joint account statute. So we have this Chapter 100 piece of law that's out there that the courts have been parsing out as far as what does it mean when you're added to a joint account, right? Is there some kind of bright line moment where you no longer are the only owner of the account but someone else owns it? The original draft of the bill that was submitted to LCB was actually mirroring a Florida statute that actually came from the opposite end, that said if a senior or a vulnerable person is deprived of their funds to the point where they don't have food, shelter, et cetera, then you could pursue that joint account holder or that other trusted caregiver criminally, but that was overbroad. So as far as saying a joint account is not an affirmative defense wouldn't address the fact that we have Walsh and we have NATCO both coming in and saying that you must establish that criminal intent arose prior to the funds being deposited into a joint account. It's just an incredibly difficult burden. I would defer to also my colleague in the South as far as, she's doing more day-to-day litigation of the criminal side. I deal more with the civil side and the ramifications of these accounts being emptied.
Colleen Baharov for the record. Thank you, Chair Scheibel. I understand that it might be easier to say that the way the account is titled is not an affirmative defense. I think the reason why this bill was drafted the way that it was, however, is just as Ms. Woodrum indicated. It's because of a couple of recent decisions from our courts indicating that we have a bar to being able to prosecute these persons unless we can prove prior to them being added to the account or the funds being deposited that they had ill intent. I think Senator Dondero-Loop's questions and Senator Harris's questions are all very valid. The question is, why would we need something like this bill to protect our vulnerable and our elderly persons? And yeah, while we can all agree that 60 today is not the same as 60 was in 1919 when the laws were written and that age was just determined to be elderly for purposes of the statute, I think the reason that we're bringing this bill is exactly for the concerns that Senator Dondero-Loop indicated, which is when we have all of the facts and circumstances, when we have the powers of attorney and the requirements that persons are supposed to just help with the bills, if we have all these other factors, the fact that that account is held in joint tenancy because someone doesn't understand the difference between adding a signer on their account and adding someone in joint tenancy, we are not going to be able to prosecute them for the crime of cleaning out that person. It is a clarifying bill. It allows prosecution where currently we cannot prosecute no matter what the other facts and circumstances are, because as soon as that person's name is added to that bill, that bank account belongs to them and they can take all of the money to the exclusion of somebody else. Senator Dondero-Loop brought up a very good point, which is when you go to the bank account or the bank, you have to have that elderly person with you. And yeah, for the most part, that is true. But if somebody is also a signer on the account, if somebody is also an owner on the account, you don't have to have that other person for every transaction that occurs thereafter. For example, in the case that I mentioned, when somebody was in hospice care and $441,000 was removed over the period of days, there was no requirement that that other joint owner also be there to remove those funds. And so this bill would allow all of the facts and circumstances for that type of case to allow for prosecution. I think at some point it may be something to consider addressing whether or not an affirmative defense could be the fact that somebody's added to an account. Maybe that cannot be an affirmative defense. But I think for purposes of this session with this bill, this just allows us to consider all of the possible facts and circumstances for prosecution and doesn't foreclose prosecution just because someone's name happens to be on an account. Thank you.
Thank you. And I think we still have some more questions. Senator Wynn?
Not to beat a dead horse here. I have some of the same concerns, obviously, as some of my other colleagues have brought up. If you have a situation where you have like a 53-year-old that's married to a 60-year-old and they are put on a joint account and they have a long marriage, and similar to that divorce scenario, or if you have a grandparent who puts a favorite grandchild on one of the accounts and then the other grandchildren start fighting about, we see so many times how many times families fight about like intent and money and the equal distribution amongst heirs. So I have some real concerns about that, and I'm wondering if the intent of making those two Supreme Court cases, if the intent was it was easier to determine what that intent was when it was formed, as opposed to what happened a week from then, 5 years from then. There's no time limit. You could be married to someone for like 40 years and then at some point change your mind and clear out your spouse's, account who happens to be older than you, even by a year, and all of a sudden you're in this exploitation of an older person. I realize that maybe those cases wouldn't be brought, but I think it just opens up the potential for litigation and conflict and fraud in that area.
Thank you for the question. Homa Woodrum for the record. I think that I have to say, as an attorney who reads a lot of legislative testimony, I appreciate robust discussion. I think it's really important that we parse out what this body's intention is. Obviously, our office is bringing something and making the case for it. But if the legislature, in weighing things, feels that there needs to be more clarification, we're certainly open to that. I would say that in the scenario of somebody who's 53, who's married to someone who's 60, that's not opening the door to an exploitation case, because exploitation requires undue influence. So sort of taking that person's trust and betraying that trust. In the marital situation, there wouldn't be the evidence of that undue influence in the addition at the moment of adding to the joint account. The additional concern is that that we've had is that the statute relating to joint accounts, sort of saying that at the moment you're added, you have joint and several ownership, didn't take into consideration the conduct after being added to that account. And that's why it's important to address these egregious cases. If the legislature would like language, it's our position that the language that would be added to Section 200 is just saying the mere fact that there is a joint account doesn't close the door to exploitation. It's not stating the opposite. It's not saying a joint account now opens you up to a claim of exploitation. It's just saying the door is not closed to bringing that case. And that's been the concern ever since the NATCO decision. Originally, when NATCO came down, various stakeholders met, and we all said, okay, we think we can distinguish this. We think we can still make this argument. We created brochures. We created outreach. Please, people, do not add people to your accounts unless your intention is to essentially give them the entire access to that account. Unfortunately, 2 sessions have passed, and it's not sticking. It's not working because there's the culture and then there's the law. Culture is that that people expect that when they add someone, they're going to abide by the rules, even unwritten rules of adding that individual. And so for people who are vulnerable and people who are older, within the context of exploitation, I guess I should be clarifying that, we have concerns about those, about exploitation. Yeah, sure.
Thanks so much. Teresa Benitez Thompson, Chief of Staff to Attorney General Ford. So when I came into the office and started looking at the bill drafts that the office had, this one stuck out. I'm like, this is my favorite bill of all session. The reason being is just coming from my previous life, being a licensed social worker, working end of life for over 12 years, hospice, inpatient, outpatient, acute care, palliative care, rounding and critical care unit through the second wave of COVID. You're just dealing with a lot of people who are chronically ill for a number of times in multiple hospitalizations, and dealing with people becoming suddenly ill. And I will tell you that the perception among people in the helping profession is pre-NATCO. The idea that you would encourage helpers to help someone in your family, and that don't worry because they can't just take all your money and run away. If you put someone on your account to help you when you are disabled, not just capacity, but a physical disability, right? That if you are using those people, they can't just take your money and run away. So part of my shock when coming into the office was, you mean we're doing these referrals to Adult Protective Services and they're not going anywhere? Oh my gosh, I'm telling you, in the community, in my community perspective was, people don't know about this on the ground. And I even told Homa, I'm like, I think that's great that you guys made brochures. They never made it to any of the folks that I work with or in the settings that I worked with. We didn't know that. And so if it's a decision of this legislature not to move forward, then we obviously need to do a much more robust education campaign out to people. But as it stands right now, I can tell you, so when you help someone apply for Medicaid, Medicaid does a 5-year look back. So if someone had someone take all of their money out of their account, then they can't get Medicaid, because they essentially, when they put that person on the account, gifted them their money. So if they take that money and go away, and they're making a case, well, that, my son took the money and ran away, or I put this friend on to help me write my checks, and then they took all the money, we would make those as a referral to EPS to be investigated. They can't do that anymore. Those referrals won't happen. they're not going to get Medicaid because they gave their money away, and they're not even going to get, well, we can have them sit in a hospital for 6 months to wait for a hearing on guardianship, but they're, if they have no funds to pay for housing, they're just stuck in hospitals waiting 6 to 7 months for a guardianship hearing, and then once you get them a guardian, the guardian has no funds and they can't get Medicaid. So you just, for those type of cases which come to exploitation through the state, this is exactly the dilemma that we're contemplating.
Other questions? Okay.
Sorry, to the last point, Teresa Benitez-Thompson, Chief of Staff. I was going to say, to your point, Senator Wynn, and maybe what we could think more about is those application to services, and they tend to, they're kind of stacked in some different ways depending on federal, state law, but most of them, some of them start at age of 60, some go to 63, go to 65, age eligibility around being like a group home or an assisted living home. Medicaid starts paying for all of those in that bracket range. So when we talk about those ages, and when HOMA says, the congruency with the Chapter 200 language, it's when those services start kicking in for people, the state to start to also provide services. So if you want a number that's more reflective of eligibility of services, we could look at that as well. If a flat 60 seemed to be offensive, we could tell you which ones come online at 60 versus 63 versus 65.
Just to follow up, I want to make it clear. I obviously understand the intent of what you're trying to accomplish here. We don't want people like being exploited. I have concerns even with your own example. I wonder how many of those people are actively giving away their money to family and relatives so they qualify for Medicaid. That may be a different conversation, but even within that example, I think it feels very vague to me, but I can get there. I understand the intent that we are trying to accomplish here with this.
And Homa Woodrum, for the record, having formerly represented Nevada Medicaid, if somebody is actively trying to gift money in order to qualify for those benefits, that's not particularly legal. So, I mean, if we're hearing about it in the, we do hear about sort of creative estate planning in order to qualify for services. I talked to an estate planning attorney once, and he said it puzzled him that some people feel that that's a goal, because while our social safety net is wonderful, really, you're so much better being able to choose where you want to be and who takes care of you and what services you get. So you're correct that we do have individuals who gift money and give away money. The issue here is we're not talking about the odd check or even them turning around and writing a check, which shows the intent of the gift. The issue is that Nevadans don't believe that when I add a joint account holder, I am gifting them that account. And that's something that we're trying to address, because people are trusting more than maybe they should because of this expectation under the law. And again, the law was the way that we could pursue these individuals under exploitation up until 2018, when the court created this very narrow intent kind of out of whole cloth based on a prior case where the original case, a power of attorney created a joint bank account and then put all the assets in it, which was a very narrow situation, versus in the NATCO case where the court could have, the dissent is fun reading if you're curious. There was some pretty angry terms in there because of this idea of completely closing the door in these egregious cases. Our hope is to open that door, not blow it wide open, not to capture anything other than the scenarios that we're describing. So I'm happy to more questions as well. I know Senator Hansen had one.
No, hold on. Senator Wynn, are you done? Senator Orenshaw is next.
Thank you, Chair, and thank you for presenting the bill. My question is tangential to the language in the bill, but I'm just wondering, since the NATCO decision, do you think there's been an effort by either state banking regulators, federal banking regulators, to try to make sure that if there's an older person or a vulnerable person, that their eyes are wide open and they understand the difference between adding someone as a joint tenant on the account versus a co-signer versus some other, if there's something else the bank can do? Just wondering if there's been any effort at trying to make sure people are aware of what they're doing.
Thank you, Senator Orenshaw. Homa Woodrum, for the record. Our banking partners are mandatory reporters under the same statutory scheme for exploitation. And the thing that we're finding with our banking partners is, as banking has become more centralized kind of with big companies. We don't have that dynamic that we used to have of sort of the family banker who might see somebody coming in and have the opportunity to advise them, maybe this isn't what you want, or to interject. Instead, they're doing exactly what they're being asked when someone's coming in with forms. So I would say that the efforts we've made is we've tried to invite banks to be part of our End Abuse in Later Life group. We have a national grant that's trying to address abuse in later life. We invite them to our coordinated community response meetings. We try to give them these outreach materials. We've not been successful in those efforts, and I can only speculate, as I mentioned, that sometimes when you have a customer asking to do something, it may not be the most ideal moment to raise a concern. And then there's the reverse side, is you don't want to seem ageist and you don't want to seem ableist, and you want to allow people to do the things they want to do with their bank accounts that they're stating. So I don't know that individuals come into the bank and say, here's my goal, can you help me get to that goal so that my son or daughter can look at my online bank account? Usually people are coming in and saying, I want to add a joint account holder. And so that's where we're trying to get the pattern sort of in practice of people to align with what our options are to help make them whole if somebody betrays their trust.
Okay, thank you, Chair.
All right, other questions? Senator Hansen.
Thanks, Madam Chair. Okay, so as I have been reading through section or NRS 200, we have pages of attempts to try to protect vulnerable people in that. So, and then undoubtedly at the time these laws were passed, one of the intentions was to protect vulnerable people in joint situations like you're describing. And then the courts came and had a very narrow interpretation of what the legislature actually intended to be broader, is what it sounds like, is what you're trying to correct. In other words, you are here today trying to get back what the intent of the legislature was, so when these kind of situations happen, you can use your legal authority, and it's not supposed to be narrowly tailored to the tiny window of time at the beginning of the joint tenancy of the account. Is that correct? Because we're almost arguing against you doing what we want you to do.
Thank you for the question. Homa Woodrum for the record. I think that the unique situation is that we have a chapter that deals with elder exploitation, vulnerable person exploitation, sitting in Chapter 200.
Yeah, in great detail, I might add.
We have Chapter 100, which is meant to give instruction to the banks, as Senator Orenshell pointed out, about how to handle a joint account. So it's our position that the legislature never thought that a provision that helps banks handle joint accounts would be used to block the intent of pursuing exploiters and people who seek to abuse and neglect individuals who are vulnerable in our community. So I think that that's where the potential for an amendment would be to, in Chapter 100, where it's saying the mere fact that an account is held in joint tenancy does not convey all assets, would be to mention older and vulnerable adults, or even just create a reference back to NRS 200. So perhaps simplify Section 5 and say, sort of a C also there, so that you would make anybody who's interpreting it, say a court, please go back to the section on exploitation. We aren't trying to disrupt the lay of the land as it comes to joint tenancy of the average bank account, but we're talking about a really unique situation. I did have a judge once ask me, why is adult protective services in Chapter 200? That's a criminal chapter, and that's just kind of how our statutes have evolved over time. 200 is a pretty weighty chapter. It goes through all sorts of crimes, and that's definitely where our office would like judges considering the intent of the legislature in Chapter 200 versus a banking chapter that's meant to make it clear about who owns an account when you add to it. So the intention would not be to make a gotcha for the banks to say that you're inadvertently assisting in this, in something that's negative or detrimental to your account holders. It would still allow them to operate as they do with joint accounts. Thank you.
Okay, well, I think I've got it, but bottom line is you guys are essentially trying to make sure that the intent of the legislature to protect vulnerable senior citizens in particular from these types of exploitations happens, and that you have the tools you need to properly prosecute people that have abused this sorts of situations. It seems totally reasonable to me, and actually it seems like you are actually complying with the intent of the Nevada Legislature.
So, Teresa Benitez Thompson, Chief of Staff, when we had a meeting about how to talk about this bill, because we wanted to say, we're like, is it going back to preset? And we kind of came up with this this timeline thing. We just, in the continuum timeline and branches of universes, NatGo branched off a new universe. We want to go back to pre-NatGo and the understanding and the status quo from there about how we were able to go about and do this work. So that's what we're looking for, is to fix what we would say is an arguing is a disruption in the timeline, interpretation timeline.
Very good. Thank you, Madam Chair.
Thank you. Senator Stone.
Thank you, Chair. Thank you for the presentation, and I certainly support the spirit of what you're trying to do. And the way I understand it, as one of the two non-attorneys on this committee, is that if somebody had a premeditated desire at the time they became a joint tenant to rip off the other one, that's where the law would be engaged. But if they became a joint tenant and later had a nefarious desire to abscond the funds, that's where you're running into your problems, correct? Okay. So just a quick example. My dad was living in Los Angeles. He had early dementia, and somebody came by the house and said, you're having some complaints from the county with the paint of your house. You need to repaint your house, so you're going to be getting a citation, and got him to spend like $30,000 on a $5,000 paint job. And that's when my sister and I decided, no, we need to be involved. I became the joint tenant and took care of my dad's affairs, and everything was handled perfectly. But what happens when you have somebody that has an advance directive, that something happens to them? Let's say they get into an accident, become cognitively impaired. Let's say they begin to have Alzheimer's disease, and they have no children. A cousin says, hey, listen, I can help you with your affairs. Just sign me on. I'll pay your bills for you. And then the relative, or friend, if for that matter, convinces the cognitively impaired or the patient or person with early Alzheimer's, says, my brother just got fired from his job because he doesn't have a car, and if he doesn't get a car, he's going to lose his house, he's going to lose his job. He needs $40,000. Would you agree to, give him the money? And the person being cognitively impaired or having early Alzheimer's gets talked into giving the money, and then that cleans out the bank account. How do you deal with a situation like that in aiding your ability to prosecute? Because I'm sure you see, at least I've seen in the many years that I've been working in county government, that this is not the exception, this is the rule. I mean, we see a lot of senior citizens and people that are vulnerable get taken advantage of, and oftentimes it's by somebody they knew, whether it be a friend or whether it be a relative, and we need the protections that you're seeking here today.
Thank you for the question. Homo Woodrum, for the record, just as a clarifying question, the scenario that you presented is vulnerable person has a family member jointly on the account, and then now a third party has kind of come into the picture and is asking the vulnerable person or the joint account holder to give
The joint account holder says, I have a relative or I have a friend that is going to lose their job because they don't have a car, or their car was demolished in an accident, had no insurance. They need $40,000. You know who this person is. I hope you'll consider helping this person out. The person says, yes, of course I'm going to help Johnny out, gives them the $40,000, and they have no money in their account anymore.
Thank you, Homo Woodrum, for the record. And the beginning of your scenario said that there was some sort of advance directive or some sort of legal tool that was implied. And that would be kind of the, a scenario where someone who has, for example, power of attorney or some authority over account has a fiduciary duty, right? They have an obligation under law to behave, sort of put themselves in the shoes of that account holder and act consistent with sort of their interests, which is different than what people are doing when they have no estate planning whatsoever, to secure, this is what I really meant when I added you to the account. In this classic joint account situation, they add the cousin or the family member to the account, and the law at the moment would say both of them have the joint and several right to use and enjoy that account, which is fine. The issue is when these cases come up for referral, the triggering event for referral would be this person's no longer making their rent, this person's not paying their doctors, this person needs to qualify for benefits. That's usually a triggering event that would make us go back and look at that account and say, wait a minute, $40,000 flew out of this account 2 years ago. We're in a 5-year Medicaid look back. They're now possibly seeking hardship waivers to qualify for services. So I would say that that Senate Bill 61 is not sort of on an island. There are other tools, there are other things that would come into play. People could continue to make gifts. The issue is that when you make a gift that's against your own interests, and you are vulnerable, then we start to ask whether you really understood what you meant to do at the time. Because if you or I want to turn around and give our money away, we're more than welcome to do that, and the law shouldn't tell us that we can't. The issue is that we worry when somebody is possibly in that vulnerable state, that someone would exploit them, and they may well-meaningly not realize that by giving that $40,000, they may expect it to come back. They may expect that that person might pay them back, and they don't get any of the legal safeguards, the contracts, the leases, the loans that, that somebody who, and again, plenty of people make poor decisions with money, and they're free to do that. But this particular population, we're really concerned about them making decisions against their own interests with sizable funds, and that's where undue influence comes in, is that trusted cousin or family member trying to wheel and deal kind of with the older adult when they know better, right? They know that this is not a simple ask, that they're using their confidential relationship to sway that individual's decision making. And again, you've seen one case. I mean, each of these are fraught with family strife, with all these sorts of things, and our position is that these are already incredibly difficult cases to bring, but the fact that a joint account is involved seems to be closing the door to otherwise valid prosecutions.
Thank you very much.
You can go ahead. Did you want to add something, Ms. Baharov?
I did. It's like you know me or something, Chair Scheibel. So I think Senator Hansen and Senator Stone had a good question. Senator Hansen asked if this bill is an attempt to clarify the intention of the legislature. And yes, it is absolutely an intent to clarify what the legislator meant to do that was narrowed by the court. In terms of Senator Stone, you're asking whether or not we would be able to prosecute a person who maybe took $40,000 or so from someone's account when they're a joint tenant holder. I would suggest to you now, at the state of the law as it stands, we would have a very difficult time prosecuting that person for taking that money because of the NATCO decision. Because maybe when they were added to the account, they did not have the intent to take all of that money. But something happened, as Ms. Woodrum mentioned, some triggering event caused them to need additional funds, and that's when they chose to dip into the money that was placed there by the original account holder. So yes, we are intending to clarify the intention of the legislature with this bill to allow prosecution even if an account is held in joint tenancy, and to then be able to look at all of the factors that are associated with the particular case to bring a case. And finally, Senator Wynn asked some questions about persons who maybe got married when they were a little older, and she indicated it's possible those cases would not be brought. I am the team chief of the Elder Abuse and Major Fraud Unit here in Clark County. I can tell you that we are not prosecuting husbands and wives for using money in their joint account. What we are attempting to do, which we are currently not really able to do, is to prosecute persons who are added to a bank account to assist in a caregiving role, some sort of caregiving capacity that we can no longer prosecute them because, well, the person who added them to the account did not realize what they were doing when they added in a joint account holder. So hopefully that clarifies some of the concerns raised by the senators. And thank you, Chair Scheibel, for letting me speak.
Thank you all for your time and answering our questions. I think I got to all of them. I'm not seeing anybody raising their hand. So again, we really do appreciate your time and taking the, having this discussion with us. So with that, we will move to testimony. We'll start with testimony in support of SB 61. Is that what we're on? 61, sorry. And with anybody who wants to testify in person, go ahead and make your way to the table.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in support of SB 61. Some things I want to make clear is that this bill does not change any criminal penalties, and it does not change any existing elements to any criminal offenses. It simply allows law enforcement to consider all of the evidence in a particular case and not just the evidence at a particular point in time. So I want to use Senator Dondero's loop Senator Dondero's loop's example for a second.
Say that 3 times real fast.
So when a person goes with their parent to add themselves to the parent's account, it all could be on the up and up at that point. Everything is perfectly legal. After that point, the person added to the account decides to take every single penny out of that account. What NATCO says is we cannot prosecute them for that. Period, end stop. So you can, when Senator Dondero Loop was added to her mother's account, which was legitimate, after that point, she could take every dime of her mother's money, and there is nothing we can do about it. NATCO decision has made our vulnerable citizens and our seniors more vulnerable. And what this bill does is restore balance. Thank you.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Cadence Matievich, and I represent Washoe County. We are here in support of the bill under the understanding that it is intended to provide protections for older and vulnerable persons. Particularly, our Public Guardian's Office sees instances like you've heard described today, where it would appear that all of the evidence points that there was a nefarious intent. At the point that the account was created, we don't know, but after that, the circumstances certainly show that, but that they have no opportunity to pursue restitution of those funds on behalf of that individual. Thank you.
Good afternoon, Chair Scheibel and committee members. For the record, my name is Steve Walker. I'm representing Lyon and Douglas County. I think that to get right to it, it's from the Public Guardians, a comment to this bill. This solidifies the ability of a guardian to recoup funds from protected individuals that are being exploited by joint account holders. Agree with the legislation as written.
Thank you for your testimony. Did you want to go ahead and testify in Las Vegas? Go ahead.
Yes, thank you, Madam Chairperson. My name is Colin Haynes. I work for Las Vegas Metropolitan Police Department. I'm here on behalf of the department. In 2003, I testified before the legislature on a bill draft that was brought forward, adding conversion language to the definition of exploitation under NRS 200-5092. That was brought because I was working exploitation cases at that time, and the very scenarios that have already been brought forward, we were seeing those a lot. An elderly person who would add a trusted person, a family member, as a joint signer on their bank account, and subsequently the joint signer would steal the money that was not theirs. The statute was passed at that time, and that language was amended. To Senator Hansen's point, the current bill draft request seems to really just try to reverse the NATCO decision and put back in place what was discussed before the legislature in 2003 and the situation that existed when the statute was amended. So the department, Las Vegas Metropolitan Police Department, supports this bill. Thank you, Madam Chairperson.
Thank you for your testimony. I don't see anybody else coming to the table to give testimony and support in person, so we'll go to the phone for testimony in support of SB 61.
Thank you, Chair. If you would like to speak in support of SB 61, please press star 9 now to take your place in the queue.
Support of SB 61. Hello?
Go ahead, we can hear you.
This is Kathleen Jones with the Elko County Public Guardian's Office. I've been the Elko County Public Guardian for 21 years. I had a case, and I've had many cases of exploitation, but the one that is near and dear to my heart that I it hurt to have to give this case to the Attorney General and the District Attorney of Echo County and nothing be done of it was I was appointed as the guardian of an elderly person. This person trusted his son to take care of him while he was older, and this older man did get frail physically and mentally, which then a guardian was appointed. The older person sold his family home, and this was his retirement savings. This was his nest egg for the future care of him when he was older. This is where his retirement and Social Security check was deposited in which this was the checking account that his son opened with him. He opened the checking account, and within 8 months, every dime of this money was taken. Eventually, the first month went by, and this gentleman, I had to pay the nursing home fees, and there was no funds to be found. $327,000 was gone in 8 months. Evidence showed the son made several large withdrawals, which included giving himself and his wife a $25,000 Christmas present. Also, there was a home bought, and there was a hefty down payment done on this home while the gentleman was in a nursing home. The son was able to get away with exploitation of his father because of this law, because of the joint tenancy account. The son was able to spend every single dime, including the deposits of the victim's Social Security. So while the victim was in a nursing home, I had to find a way to pay his nursing home patient liability. I applied for Medicaid for the victim, and he was denied during the first application process because he had $327,000 a year ago. But where did it go? Did he give it away? And is he now trying to fool the system that he needs Medicaid? And because Medicaid requires a 5-year look back. This was not the case. He did not give his money away. It was stolen by his son. The guardian had to jump through the hoops of Medicaid and I had to eventually apply for a hardship waiver with Medicaid to be able to pay for his future nursing home benefits. So you can
And you're at
probably
about
guess
2
who
minutes.
eventually paid for.
If you could wrap up.
So you can imagine. Okay, so you can imagine probably who eventually had to pay, and this was the taxpayer. I would appreciate your time and consideration. Thank you.
And we also need you to spell your name for the record, please.
Kathleen, Kathleen Jones, Jones.
Thank you.
If you have just joined us and would like to offer support for SB 61, please press *9 now to take your place in the queue. Thank you, Chair. There are no other callers to offer support testimony at this time.
All right, then we'll move to testimony in opposition to SB 61, starting with those in person in Carson City. It looks like we're alternating between seeing Las Vegas on the screen and seeing this Bluetooth pairing. Okay, it looks like there's nobody in Las Vegas, so I'm just gonna make a record of it now, and we're gonna do a testimony in Carson City.
Thank you, Chair and members of the committee. John Pirro from the Clark County Public Defender's Office. We understand the intent of this bill, and we're not objecting to the intent. We actually would like to see the intent carried out, but perhaps in a narrowly tailored way to capture the right people. And some of the language in the bill we felt was too broad, and we thank the sponsors for speaking with us about that, and we think we'll be able to find a comparable fix. There are some concerns that Senator Harris brought up, and perhaps using rebuttable presumption language may make this a cleaner bill or a cleaner legal standard for finding this. There also are the concerns that were brought about by Senator Nguyen and Senator Dondero Loop. We've had cases where a grandfather is seeing a new partner, and the grandchildren are not as happy about that new partner as the grandfather is. And so when something happens later on and the grandchildren see the money that they may be entitled to dwindling, they get upset and they go complain to the district attorney or law enforcement. And then those cases, we work them up and get them dismissed, but the person is charged with a crime and they're under the fear of incarceration during that time. So there are ways that we could fix this. And I think making the language clear is probably the most important part, because as Justice Scalia said, trying to use legislative history in your briefs is like looking at a sea of your friends and picking out the ones that you like the most.
Good afternoon, Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. I echo the sentiment of my colleague, Mr. Pirro. I'm just simply going to add, and this is in relation to Section 5 and the broadness of that, and a fact pattern that I would pose to all of you to think about is that what happens when we have a married couple and one of them, we can say in this case the woman, is the victim of domestic violence. Now, she has a right to the money in the account. It's a joint tenancy, and she's actually legally entitled to half of that. If she were to attempt to leave that marriage, take a large portion of it, can this now be used against her as a tool in custody hearings in an attempt to invoke more control over her? And so when we're talking about language that is this broad, I think that's just what we're trying to hone in on. I do believe in the intent of the bill, and I thank the sponsor for being willing to working with us. But that's just, I think that especially under Section 5, we need to really determine who is going to fall under that and who we don't want to. Thank you.
Thank you for your testimony. I don't see anybody else in Carson City or Las Vegas to give opposition testimony, so we will go to the phones, please, for testimony in opposition to SB 61.
Thank you, Chair. To speak in opposition to SB 61, please press star 9 now to take your place in the queue.
Good afternoon. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. We're opposed to this bill for the reasons discussed by Mr. Pirro and Ms. Ross. Additionally, I wanted to share my personal experience. My yaya is 91 years old. She's almost 92. It's her birthday later this month. She's in a hospice in Ohio. Hospice is paid for by Medicaid. My yaya cannot manage her own money anymore, so my mom and my aunt are on a joint bank account with her. Turns out that if you have Medicaid and you're using it to pay for the hospice, there are lots of fiddly little rules about how much money you're allowed to have in the account and what things are and aren't allowed to spend it on. So it's basically not quite a full-time job, but it's definitely a part-time job for my mom and my aunt to manage the bank account, make sure they're complying with all of these state Medicaid rules. They have to jump through a lot of hoops for that. Part of my concern with this bill is that it's creating a new set of hoops related to criminal prosecutions of people in their position. So now there's suddenly this entire other set of rules they have to follow to avoid getting accused of stealing. And of course, you know, for people in that situation, this is very emotionally difficult for them. You know, they're dealing with the health decline of their mother, and now they have to worry about prosecution as well. So that's a concern we have. We want to make sure that the language in the bill does not unintentionally enable prosecutions of people in my family's position. And so for right now, we oppose this bill. Thank you.
Thank you, Chair. There are no other callers to offer opposition testimony at this time.
All right, then we'll go to testimony in neutral on SB 61. I don't see anybody coming to the table in person in Carson City or in Las Vegas, so we'll go to the phone lines.
Thank you. If you would like to offer a neutral testimony to SB 61, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers to offer neutral testimony at this time.
All right, then if the presenters have any closing comments, we would welcome you back to the table.
Thank you. Homo Rodrum for the record. I want to thank you all for your incredible sensitivity to the circumstances for individuals across the lifespan, whether you're thinking as a caregiver, whether you're thinking about somebody who may in future receive care. I think that this discussion highlights how much your guidance is needed. And for those who have mentioned, concerns about where would Senate Bill 61 take us in the future, we already have a preview of that, and that is the state of the law pre-NATCO. We did not have rampant prosecutions of the scenarios, of the day-to-day use of joint accounts, but we did have the possibility to bring appropriate prosecutions to assist our social services partners, to make people whole who have, had their trust misplaced. And we appreciate your consideration, and we appreciate the opportunity to continue to work with those who have given their comments about tightening up bill language, and all of you as well. So thank you so much for your time.
Thank you. Did you want to add anything?
No, thank you very much.
All right, then that concludes our hearing on SB 61. I will now close the hearing, and that brings us to the last item on our agenda, which is public comment. If there's anybody wishing to give public comment in person in Carson City or Las Vegas, please make your way to the table now. I'm not seeing anybody, so we'll go to the phone lines for public comment, please.
Thank you, Chair. If you would like to offer public comment for today's meeting, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to offer public comment at this time.
All right, then. We will be back here tomorrow, same time, same place. Until then, we are adjourned.